Good morning, everybody. I'm your host, the Supreme Litigant. I'd like to welcome everybody back to Smart Loc TV. If you haven't already, please go ahead, hit that like button, hit that subscription button, and turn that notification bell on. I'll give you a few seconds to do that. All right, y'all. So I have a very, very interesting case for y'all. Very interesting. So we're going to be talking about territorial jurisdiction because that's what I've been studying. And I haven't done a lot of studying on it, but based off the study that I have done, I'm going to say that I'm about maybe 85% right about almost everything I'm going to say in this video. Now, keep in mind that I'm not an attorney. I don't want to be an attorney ever. And my reasonable conclusions that I make in all of my videos are subject to change whenever I receive new information. There's a possibility that my opinions may change about some things, some stuff that I say. So without further ado, I'm gonna go ahead and get into this one. Now, this is a very, very interesting case that I found yesterday. It's not too long. It's from 1927. You can find it in Alabama Court Reports, Volume 113, South 10. All right. So this is about a town called Central that it's not within the territorial jurisdiction of the legislature. All right, now let me pause this right quick because there's a post on my YouTube channel that I want to provide you some commentary on. All right, so give me a second. I'm gonna pull it up and I'll be right back. All right, this right here. This is the post I want to talk about. Now this video I'm gonna try to keep it at about 30 minutes, and I'm gonna probably do another video. This is going to be, it's probably going to be a long video. It may be an hour. I don't know. It depends on how long it takes me to read the case and just explain this stuff to y'all. But anyway, so I want y'all to pay attention to this. I'm going to read it out. Just as Congress has plenary power over their territories, the state legislatures have plenary power over their territories, i.e. political subdivisions, aka cities, towns, or counties, or all of them. Once they create a political subdivision, they, in my opinion, also create a government for it. For example, a city council. However, the government that they create are ministerial officers performing ministerial duties that are mixed with quasi-judicial and quasi-legislative duties because it, the city, town, or county, or whatever you want to call it, is an administrative agency. So this, based on the case that I'm about to show y'all, I made a mistake just a little bit. Once they create a political subdivision, they, in my opinion, also create a government for it. They cannot create a government for any city unless they own the land. They have to get permission from the people who own the land because they don't own the land. That's another thing that this case, what I'm going to read to you, is talking about. However, it is an administrative agency. So what do I mean by city is an administrative agency? So what, in a sense, what y'all are dealing with, and this is based on my own reasonable conclusions, you're dealing with a territorial government. That's what you're dealing with because you're in a territory. All right. So what do I mean by the city is an administrative agency? Okay. Well, administrative agencies exercise all three powers of government. Although these powers are not authentic in the sense that they were given to this administrative agency by the sovereign people of Alabama, Georgia, Mississippi, whatever you want to call it. All right. So let me give you an example. Does not a city have a city council? All right. That city council is exercising quasi-legislative functions or duties. All right. Doesn't a city council, doesn't a city have a municipal judge that is exercising quasi-judicial authority? Does not a city have an executive branch of government, aka a mayor, that is exercising quasi You know what? As a matter of, I wouldn't even call the mayor, because the mayor, because administrative agencies are executive, they're members of the executive branch of government. So I wouldn't say that the mayor is exercising quasi-executive authorities, because I mean, administrative agencies are members of the executive branch of government. So that means the so-called judge in the municipality, the legislatures, and the mayor, they're all executive officers. They're mixing this stuff, and you can't tell. You can't see it. They wearing so many hats, you don't know. But let me get back to this case, because this case is very interesting. So let's get to it. The boundaries of the municipality were fixed in accordance with the plat attached to the petition for incorporation. They're trying to create a corporation. They're trying to incorporate that city. The property involved, not being described herein, was not embraced in the corporate limits. I told y'all they corporations. There being no subsequent proceedings to enlarge the boundaries of the town, the mere payment of taxes by those residing out of the corporate limits, voting, being candidates, or holding office in the municipality would not be sufficient to extend the corporate limits. The corporate limits. It's a corporation, y'all. You know, let me see. Well, they're actually going to mention this right here. They're going to mention that within the case, all right? Because this seems to be what was just held down here by the so-called judge. So I'm going to go ahead and read that. But y'all can read that if y'all want to. All right. So look, in the proceeding to incorporate the town of Central to the effort was to follow the prescriptions of section 1486 of Code 1886. So this town of Central, it's not right now, until it was incorporated, it was outside the territorial jurisdiction of the legislature. All right. So it was not within the territorial jurisdiction of the legislature. All right. Which reads as follows. I want y'all to notice that they use the term inhabitants. I think that's interesting. The inhabitants of a town not incorporated, the population of which is not less than 100, nor more than 300, may become a body corporate. All right? A body corporate. What is a body corporate? It's a corporation. Upon a petition in writing addressed to the judge of probate of the county in which they reside, signed by 20 or more of the adult male inhabitants, stating the name and boundaries by which it is proposed to incorporate such town. But the boundaries of such town must not be fixed until the majority of the owners of the real estate situate within such boundaries have, in writing, signed by them and filed with the judge of the probate, expressed their assent to such boundaries, their consent to such boundaries. So they don't have, so in other words, this town was, like I said, was outside the territorial jurisdiction of the legislature, meaning that there were no police in that city. I mean, in that little town. There was only a sheriff, because the police have zero. Give me a second, y'all. Let me pause the video. Give me a second. All right, sorry about that, y'all. I'm back. But back to what I was saying. Before this town incorporated, there was no police force. All right. So what do I mean by that? What would I mean? The only officer was a common law officer that could come within that town, which would be the sheriff. All right, because the police, they have zero jurisdiction outside of their corporate limits, outside of their territorial boundaries, or so to speak. All right. So what do I mean by that? Let me show y'all something right quick. All right. An off-duty municipal officer outside his jurisdiction has no right to arrest other than as a private citizen. So that is a common law arrest. So what I'm trying to tell y'all, these are two different jurisdictions. One is common law and the other one is not. All right. So they want to incorporate, they want to do business. All right. It will be observed that the section requires that the petition for incorporation must state the boundaries of the territory which it is proposed to incorporate, but that the boundaries must not be fixed until a majority of the owners of the real estate situate within such boundaries have in writing signed by them and filed with the judge of probate expressed their assent to such boundaries. So I'm going to stop right there and let me explain something else to y'all. If statutes were laws, all right, if statutes were laws, then why does this town need to go through this? Why do they need to petition the probate court to come within the territorial jurisdiction of the legislature? They could have already done that just by statutes being laws and just by the legislature having supreme authority over all of the. They can't do that because one, they need their permission. They need the owners of this land. They need their permission to do that. Now I want y'all to pay attention, all right? If statutes were laws, keep that in mind. Out of the prescriptions has arisen the question now submitted for adjudication. Petition, excuse me, I got something in my throat. I'll be right back. Sorry about that, y'all. I left something out also. I want y'all to know, I want y'all to pay attention that this town, this is a common law town, all right? This town existed without the legislature, all right? But what this town is doing is they are making themselves subject to the jurisdiction of the legislature. They are voluntarily doing that. And once they do that, then the statutes over that particular territory have the same force and effect as law. Does that make sense? Because that is what is going on. That is exactly what is going on. Statutes are not laws. If statutes were laws and the legislature was supreme, there would be no need for this town to do that. And if the legislature owned everything, there would be no need for this town to do that. But they don't own everything. They're not sovereign. All right? And they can't force you to do something against your own will. Out of these prescriptions has arisen the question now submitted for adjudication. Petition was filed on April 2nd, 1892, describing the proposed boundaries of the town by reference to a map filed therewith. The petition was signed by 26 persons describing themselves as citizens and residents of Central. If a citizen and a resident mean the same thing, then why does this word "and" right here? That's because they don't mean the same thing. By citizens and residents of Central and Mobile County. On that day, the judge of probate made an order for the election, the concluding clause of which reads as follows. The boundaries of such town will not be fixed until a majority of real estate owners situated within the boundary applied for is signed by them in writing, filed with the probate judge, expressing their assent to such boundaries. Assent means their consent, their permission, their acquiescence, their agreement. The transcript shows a copy of a paper purporting to be the petition of 49 persons describing themselves as citizens of Central, that the boundaries of the town to be fixed as shown by the plat attached indicating a territory somewhat larger than that shown on the map filed, on the map first filed. This petition was dated April 18, 1892. On the same day, an election was held, 56 votes being cast for incorporation against 9. In undated paper taken from the minute book under date of March 25th, 1893, purports to evidence the assent of the signers, 21 in number, owners of real estate in the town of Central, to the corporate limits as described in a map on file in the probate court of Mobile County. April 20th, 1892, the probate court entered an order declaring the town of Centennial incorporated, with the boundary designated in the petition. Appellants own real property in that territory shown by the plat, or second map in excess that is shown by the first map. Their property was assessed for taxation. Now they can tax you. How can they tax you now? Because they couldn't tax you first. But how can they tax you now? It's simple. Because they were given a charter by the legislature. And that legislature authorized them to tax everything within that territory. Paying taxes is voluntary. You can have a common law city, private city or whatever, and you can still pay taxes. You have to agree to pay taxes, though. You know what I'm saying? So you can do that in an unincorporated town. This property was assessed for taxation for the tax year of 1922 to 1923. In due course, a decree was entered ordering its sale for the payment of such taxes. It is agreed between the parties that the question involved in this appeal is as to the right of the town of Centennial to levy and collect taxes on the property of W.S. Hinkle and H.A. Hinkle, and the right of the town to tax the owners of the said property is dependent on the determination of the boundaries or corporate limits of the town of Centennial. It is a corporation. That is what it is. It is an administrative agency. That is what it is. They are doing business. All right? It's all business. The evidence disclosed the fact that since 1892, the municipal authorities have exercised jurisdiction in the disputed territory. So to speak of the territory in which appellant's property is located, levying and collecting taxes and otherwise, and that the residents of that territory had exercised political privileges and prerogatives as residents of the town of Centennial. These are privileges that they can do that. Some of them holding office in the municipal government. In the proceeding to collect taxes, appellants interposed their contention that the municipal government had no jurisdiction in the premises. Proceeding for the incorporation of the town were defective, or rather, the record thereof fails to show just what relation to the second petition and map bore to the first. The appellants contend that the record, so to speak of, the maps and documents shown in the transcript, shows an incorporation according to the first petition and map, and fails to show an amendment or extension according to law of the municipal boundaries to include in their property. Proceeding to incorporate, or rather the evidence of that proceeding, was left in a state of so much confusion. The order of the probate judge does not improve this situation. So he says the order of the judge, it's still confusing. I guess the so-called judge didn't know what he was doing either. He made some sort of error, something like that. It is of doubtful meaning in itself, nor can it be regarded as anything more than a ministerial notation of what was done. Nor would it, though of certain meaning, preclude inquiry into the validity of the proceedings. It does not evidence a judicial ascertainment of the result of the proceedings. There are two sufficient reasons why it must now be determined that the map or plat showing the larger area, thereby including the property of the appellants, furnishes for the purposes of this proceeding a correct description of the corporate limits of the town of Centennial. It's a corporation. They all are, generally speaking. Give me 1 second, y'all. I'll be right back. 1. For nearly 30 years before appellants set up their contention to the disputed area, had been on all hands treated as part and parcel of the town. Appellants, in common with all other inhabitants of the area, are now stopped by acquiescence. He's saying that they are stopped by acquiescence. They are stopped by their consent. They waited 30 years to try to come back and nullify this. That's what essentially what it's holding. are stopped by acquiescence in the boundaries so recognized and treated as lawful. Long acquiescence in the location of municipal boundaries, although indefinite and uncertain, by the local corporation and the inhabitants thereof, and where all municipal action and improvements have been done under the assumption that such are the boundaries, will support the conclusion that such are the true boundaries, notwithstanding they were not originally so located. And there's the cases right there to support the contention, where this doctrine is discussed at length and the authorities are cited. So this is the authorities while they're citing what they're saying. This is where they're getting that authority from, that ruling. All right. The municipal corporation has now organized and functioning is at least a de facto corporation. In other words, an in fact corporation territorially coextensive with the limits in which it has exercised its governmental functions. The present attack is collateral. They're trying to dissolve it. That's what they're trying to do. They're trying to dissolve that municipal corporation. The existence of a municipal corporation cannot be destroyed or its governmental organizations annulled in a collateral attack. And then that's where they're getting that opinion from. That's a good case right there, too. I'm going to read that one, too. I'm not going to do it today. Might be a little later today, but that is a good case right there, too. Because I read that one today. The judgment of the circuit court affirming the right of the town to levy and collect taxes in the disputed area must be affirmed. All right. So this town, Central, they incorporated, voluntarily acquiescence and made themselves subject to the jurisdiction of the legislature. And since they did that, they were given a charter. That charter is their constitution. That charter tells them everything that they can do. It tells them that they can have a so-called municipal court, a city council, a mayor, and it lists all of their duties. It's an administrative agency. However, this is an administrative agency not of the people, but of the legislature. That's what they're doing. They don't have any judicial authority in there. And a municipal judge has no judicial authority whatsoever. Now, they may have in your particular state. I doubt it, but I know they don't in Alabama, and I'm going to prove it to you right here. I've read this plenty of times. This is probably, well, not plenty of times, but about 4 or 5 times. I'm going to read it again. This case is based on State ex rel. Winter versus Sayer, 100 Alabama, blah, 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 where in dealing with the distribution and exercise of the judicial power, it was said the system is in itself and of itself complete. And though there has been a grant or reservation to the General Assembly, that means the legislature, of power to establish inferior courts of law and equity, because theirs can never be superior to the sovereign people of Alabama, because it was the sovereign people of Alabama who brought the legislature into existence. They created the legislature. All right. There has not been any, let me read that for y'all again. There has not been any part or any fraction or any fragment of judicial power left in abeyance. They're saying that even though the legislature is authorized to create inferior courts of law and equity, there has not been any judicial authority left over or held somewhere for them to use to establish these inferior courts. That's what they're saying. Let me read that for y'all again. There has not been any part or any fragment, or any fraction or fragment of judicial power left in abeyance, awaiting the happening of any future event or the exercise of future legislative power to vitalize or quicken into activity. If the legislature, which is General Assembly, never exercised the power to establish inferior courts with which it was clothed, and its exercise is purely a matter of legislative discretion, the whole element of sovereignty known as the judicial power would still exist, confined to the tribunals, which may properly be said of the constitutional creation. I'm going to read that for y'all again. If the General Assembly never exercised the power to establish administrative agencies, that's what they are. I'm going to call them that. They're not courts. With which it was clothed, and its exercise is purely a matter of legislative discretion, the whole element of sovereignty known as the judicial power would exist. It would still exist. So it's not dependent on the legislature. The judicial authority is not dependent on the legislature. All right? It's not. Because they don't have any judicial authority to give away and use. Because it doesn't belong to them. Let me go back to this post, right? I'm gonna explain something else to y'all. The reason why I say these administrative agencies are exercising quasi-judicial and quasi-legislative duties and so on and so forth like that is because the ultimate, or in other words, the supreme legislative power does not belong to the legislature. The supreme judicial power does not belong to the judiciary. It belongs to the fourth supreme branch of government, which is the people, because the people are a coordinate department of the government. That is why the people, and I've said this over and over and over, can nullify at will every Supreme Court decision that they don't like whenever they want. That is why the people can nullify a statute. How can you nullify a Supreme Court decision, but you can't nullify a statute? Because they call it jury nullification. Juries can nullify a statute. If they say you're not guilty, I don't care what type of evidence if they say you're not guilty, it's a wrap. And the people have nullified Supreme Court decisions by amendments to their Constitution. You can change that Constitution whenever you want. You do not have to wait every 4 to 6 years. You don't have to do that. You don't have to do that. That's what they want you to think, though, but you don't have to do that. All right. I'm gonna pause the video and I'm gonna see if there's anything else that I can that I missed to talk about in this video. I'll be right back, y'all. All right, y'all. Yeah, that'll be the end of this video. The next video I'm gonna do, I'm gonna read this case next. I'm about to do this once I upload this video and do this one. This is a very interesting case. It's about 7 pages. It's very interesting. Very interesting. This case right here, pretty much it solidifies that this is all business and that this is a corporation. All right, that they're corporations. This is where another city, so-called city, but anyway, it's a town called Talladega. They incorporated. You know, they're going to mention that their charter, right? See, when the charter provides, blah blah blah. It's the charter. All right, but I'm gonna read that next. Anyway, that will be the end of this video. The Supreme Litigant is out. Peace.